Good afternoon and welcome to the Regulatory Transparency Project's webinar, Utah versus Sioux, DOL and SEC regulations that encourage ESG investing. Are they lawful? My name is Steve Schaefer and I'm the director of the Regulatory Transparency Project. We are excited today to host a stellar panel of experts. If during the webinar you have any questions, please type those questions into the Q&A function. That's the Q&A function. First, our moderator, Gregory Jacob, who's a partner at Old Mulvaney and Myers LLP, where he represents clients in class actions and other litigation concerning ERISA and other labor and employment matters. He is a former Solicitor of Labor and served as counsel to Vice President Pence and Deputy Assistant to the President. We are proud that he is the chair of RTP's Labor and Employment Working Group. Next, we have Sharon A. Rose, who is managing partner at Rose Legal Advisory, PLLC. Sharon previously served as senior counsel in the Office of the Solicitor at the Department of Labor, where she advised the Office of the Secretary and department agencies on a variety of regulatory enforcement and litigation matters. She also practiced a law for an international law firm in Washington, D.C. and in Singapore. We are proud to have Sharon as a member of RTP's Labor and Employment Working Group as well. The Honorable Paul S. Atkins is Chief Executive and founder of Patomak Global Partners, LLC, which is a financial services consultancy in Washington and New York that provides industry and regulatory expertise. Paul previously served as a commissioner of the U.S. Security and Exchange Commission. He was also appointed by Congress to be a member of the Congressional Oversight Panel for the Troubled Asset Relief Program, also known as TARP. We are honored to have with us T. Elliot Gaiser, who is the Solicitor General of Ohio, who represents the state of Ohio in all significant appellate matters. He previously served in private practice at both Jones Day and Boyd and Gray and Associates. He clerked on the U.S. Supreme Court for the Honorable Justice Samuel Alito and Judge Naomi Rao on the Court of Appeals for the D.C. Circuit. Now we'll turn it over to Greg. Thanks.
Thanks so much, Steve. And I'm just very excited to be here with such a distinguished panel to talk about what has become a very hot topic over the last few years of ESG investing, which stands for environmental, social, and governance factors, and reliance on those factors when making investment decisions. And particularly today, we're going to be looking at the case Utah v. Sioux, which was actually argued this morning in the Fifth Circuit, and which plays out in the context of a Labor Department regulation called the Investment Duties Rule that was issued by the Biden administration Labor Department in November of 2022, became effective in January of 2023, and it particularly addresses how ESG investing plays out in the context of investing retirement assets. Fiduciaries who are placed in positions of trust to invest the retirement assets of the workers of the United States have duties of prudence and loyalty under ERISA. And this regulation addresses the extent to which those people who are placed in positions of fiduciary responsibility can or cannot take ESG factors into account when making investment decisions. I'm going to briefly set the table for Utah v. Sioux, and then we're going to just have a lively discussion amongst the panelists that I think is going to start on the topic of ESG investing and then broaden that into a broader discussion of what we can learn from what the department has done in this area, as well as what the SEC has been doing in the area of ESG investing for its implications for administrative law more broadly. So briefly setting the table, I mentioned this rule went into effect in January of 2023. And the investment duties rule it has some sentences in it that I think are completely non-controversial. It states, for example, that when a fiduciary determines with respect to an investment or investment course of action, that those must be determined by taking into account the risk and return characteristics of those investments over an investment horizon. That's standard language that I think everybody agrees on and has been around for a number of years. It also states that a fiduciary may not subordinate the interests of the participants on behalf of whom the investments are being made to other objectives and can't sacrifice investment return in the pursuit of other things that the fiduciary thinks are beneficial for the participants. Both of those concepts in and of themselves, I don't think anybody would disagree with. But then it engages on the subject of ESG investing in particular. And it says two things about that. First, when doing a risk and return analysis, it says, and I'll quote the provision here, risk and return factors may include the economic effects of climate change and other environmental, social, or governance factors on the particular investment or investment course of action. So that is a sentence that says that when you are thinking about the risk and return characteristics, that ESG factors can be considered as part of that to the extent they actually affect risk or return of the investment. And then it says that if a fiduciary prudently concludes that two investments are equal in terms of their risk or return characteristics and what they might add to the plan, that the fiduciary may then consider collateral benefits, whatever that means, in deciding which investment to pick. And what that has been understood to mean is you can think about environmental, social, governance factors in order to break the tie, even when those ESG factors have nothing to do with the risk or return characteristics of the plan itself. So a lawsuit was filed by 26 state attorney generals, 2 private individuals, and 2 companies. That case went before Judge Matthew Kaczmarek, and in September of 2023, in the Northern District of Texas, he applied Chevron, which, as we all know, was just overturned by the Supreme Court in the Loper-Bright decision very recently, just on June 28th. But he applied Chevron at that point in time to uphold the ESG rule, the investment duties rule. And the states appealed. As I indicated, the case was argued in the Fifth Circuit this morning. And so now I'm going to turn it to our 3 panelists to sort of set the table on other characteristics of this. So I've laid out the litigation, but I'm going to ask Sharon. Sharon, could you walk us through that rule isn't the first time that the Labor Department has spoken on the subject of ESG factors and how they factor in. Can you walk us through the history of where the department has been on this and how it has addressed the subject?
Sure, yeah, and that's right. The department has been speaking on this issue generally for about the last 30 years. The department first issued formal guidance in 1994 under the Clinton administration through Interpretive Bulletin 94-1 in order to kind of address some of the questions that were starting to increase at that time about retirement plan, investment choices that were selected for non-financial interests that they might further. At the time, IB 94-1 focused on the term economically targeted investments, or ETI, instead of ESG, which is the more recent terminology, which by that they meant investments that would create some sort of additional economic benefit separate from investment return to the plan, such as a small business or a real estate investment or something along that line that would somehow benefit the group or the locality in which the sponsor operated. Prior to that time, the department hadn't really issued any formal guidance on it, but they had issued a number of advisory opinions and information letters addressing specific fiduciary questions on this topic. And then they had granted a number of prohibited transaction exemptions to specific plans that sought to utilize investments like this that provided some other sort of economic benefit. In IB 94-1, the department stated that ERISA's fiduciary obligations did not prevent plan fiduciaries from investing in an ETI asset if the asset had an expected return commensurate with returns of alternative investments with similar risk characteristics, and if the ETI was otherwise an appropriate investment for the plan in terms of the usual risk return analysis, like diversification and the investment policy of the plan, that sort of thing. So this IB essentially is what set up the tiebreaker standard that we'll be talking about more today, also known at the time as the all things being equal test. Then 94-1 sat for a while, and then under the Bush administration in 2008, EBSA replaced IB 94-1 with Interpretive Bulletin 2008-1. Now, this IB reiterated that fiduciaries have to make investment decisions on the basis of economic interests of the plan, specifically diversification, liquidity, risk return, those sorts of factors. And then the IB went on to say that where two or more investment options are of equal economic value to a plan, so that means, and they specify that that meant economically indistinguishable, that only then could fiduciaries choose between alternatives on the basis of a factor other than the plan's economic interest. So, at the time then, based on a quantitative and qualitative analysis, the fiduciaries still had to identify, and EBSA said at this point in their IB, that they thought the fiduciary would rarely be able to demonstrate compliance with ERISA unless they had fully documented the purposes for that selection and the analysis that went into it. So that was the first instance of a documentation requirement or suggestion, at least at that point. In 2015, the DOL then under the Obama administration withdrew the Bush administration's IB 2008-01 and then reinstated in full form the language of IB 94-1 through a new interpretive bulletin 2015-01. So the department at that time explained that IB 2008-1 had, in their view, discouraged fiduciaries from considering ETI or ESG factors. This was the first time that the department started using ESG in this context. And the department then explained for the first time in this guidance that ESG issues may have a direct relationship to the economic value of the plan's investment and are proper components of a fiduciary's risk return analysis. So on that point specifically, the department said that such factors need not be considered as collateral factors, but actually as part of the proper risk return analysis that a fiduciary is expected to undergo. And the department in this IB 2015-01 also pulled back on the suggestion that fiduciaries needed to document their analysis when they were using such collateral factors. So then in 2020, the Trump administration, instead of rescinding and issuing another IB, doing the flip-flop, EBSA under this administration decided to actually engage in formal rulemaking. And so the Trump administration issued a regulation that revised certain language in the CFR section that governs the rules for fiduciary responsibility. So specifically, they added a subsection to the investment duties regulation in 29 CFR Part 2550 that required fiduciaries evaluating investment options to take action based only on pecuniary factors. And they also said that a fiduciary may not sacrifice investment return or take on additional investment risk in order to promote non-pecuniary benefits or goals. So now the final rule here did not reference specifically ESG or ETI or similar terms to that. But in the preamble, the department specifically said that there are instances where ESG factors will present a business risk or opportunity that might appropriately be treated as a material economic consideration under the proper investment analysis that a fiduciary had to take there. So it didn't exclude consideration of ESG factors, but it clarified that a fiduciary had to focus on the ones that present a true economic impact to the plan. Similar to the prior IBs, the department retained the tiebreaker standard, stated that a fiduciary may consider non-pecuniary factors as a deciding element only where the fiduciary is unable to distinguish. So there's that language again from the 2008 IB, unable to distinguish between investment options on the basis of a pecuniary factors alone. But it clearly, especially in the preamble, did raise some doubts as to whether a tie really would ever exist. This rule also set up some enhanced scrutiny through a documentation requirement that a fiduciary had to follow when making an investment decision based on any non-pecuniary factor. And then the rule also restricted fiduciaries from including ESG investments in a qualified default investment alternative, also known as a QDIA. And that's a diversified investment portfolio where employee contributions are placed if an employee hasn't made a specific investment selection on his or her own. Then more recently, and the reason for this lawsuit is the new Biden DOL rule that rescinded the Trump era rule and issued a new final rule in December 2022. And like the Obama administration, the department believed that the Trump era rule had discouraged investment decisions based on ESG factors. So it took that same CFR section, part 2550, removed the subsection requiring investment decisions based solely on pecuniary factors, and they added a new subsection under a fiduciary's prudence obligations that basically state, as Greg quoted before, that risk and return factors may include the economic effects of climate change and other ESG factors on a particular investment. The key nuance here is that the department has now essentially codified in the regulation that a risk return analysis may include ESG factors. So that's going a step further than what the prior guidance had done. This rule also upheld the tiebreaker standard, but it rephrased it to say that collateral factors could come into play where a fiduciary prudently concludes that competing investments equally serve the financial interests of the plan over an appropriate time horizon, rather than where the investment options are indistinguishable. And then the department removed the documentation requirements and also removed the restriction on using ESG investments in a QDIA. So as you can see, there's been 5 gyrations here over the last 30 years, but the department across all of them has been consistent in 2 things. First, in stating that fiduciaries must consider factors that affect an investment risk and return analysis, including ESG factors, but they can only consider non-pecuniary factors under certain circumstances. And that's true both between the Trump and the Biden rules. And then this guidance has also continued to reiterate the tiebreaker standard, which we'll be talking about a little more today.
Well, Sharon, thank you for that uplifting picture of regulatory consistency and stability in the interest of the Republic.
That's right.
Just one quick follow-up question on that. So you mentioned ETI, the economically targeted investments that sort of preceded, just as affirmative action has become DEI, ETI has become ESG, nicer words to put on the page.
Right.
One of the examples that, back in the 1990s, a lot of construction unions, for example, might have had a retirement fund. And they would say, we want our retirement plan to only invest in union construction projects to the extent that they've got real estate investments that are part of their portfolio. We want to restrict it to union labor because that helps us with our jobs today. And if we get better jobs today, that's also more into our retirement fund. Do you know whether, is that permissible under all of these different standards? Did that flip back and forth? Did the analysis change much as to whether, a union would be allowed to say, only union investments for purposes of their retirement plan?
There is some consistency on that very point, I would say, across all 5. In fact, the 2008 IB even focuses on a couple examples where that might be the case. But again, it's in the vein of, is there an economic purpose here? Is there some economic benefit rather than the more lesser solidly defined ESG terms related to governance and things like that? So I would say that there wasn't necessarily inconsistency that's across these, both the Obama, Clinton, Biden era, as well as the Bush and Trump era, sort of allude to those things as being other considerations that may come up, but still in the investment context of, is this a proper, is there some economic consideration there? That's certainly one of the points that the Trump administration considered when it decided to retain the tiebreaker standard. is because there had been a lot of, or a number of plan sponsors who raised that issue.
Thanks. Well, so now we've heard what has been going on over at the Labor Department. Paul, can I ask you to speak to, we think about investing, the Labor Department governs the retirement aspect of that space, but of course the SEC has a much broader role in investing more broadly. What's been happening with respect to ESG over at the SEC?
Well, of course, it's been active in tune with, the president's announcement shortly after he was inaugurated that this was going to be a whole of government approach to, climate issues and everything else. So the SEC is being no stranger to that. So if you rewind, going back all the way to 90 years ago, the SEC just passed its 90th birthday in June. But every SEC is pretty much centered around disclosure primarily. And so Section 10B of the Securities Exchange Act basically sets forth the standard, which makes it unlawful to make a material misstatement or omission, that sets everything out gives you a true picture of what the status of the issuer is and its financials. And so that's being carried through time. There was a pretty seminal decision by Thurgood Marshall back in 1976, TSC Industries versus Northway, where, speaking for the court, he, set forth, reiterated that standard and said that, materiality is the real touchstone, and that, companies need to watch out for, information overload, that you just can't dump all sorts of stuff out on the public and then have them sort out the wheat from the chaff. So then fast forward to Obama when he became president in 2009, and in 2010 he went off to Copenhagen for a big conclave, environmental conclave there. And so in tune with that, the SEC at the time pushed through a statement by the commission about disclosure of climate issues. And basically it stuck to the whole materiality standard, which is fortunate and I think proper, and just, gave some examples and things like that of how companies should do that. But it gave some headlines that, helped, I guess, the then chairman, be in tune with whatever the administration was doing. But then you go up to the current time. And so now with the current chairman, the SEC has had this tortured path of coming out with a huge rule that would completely upend corporate disclosure. And as Hester Peirce, who's one of the current commissioners, and happy to say one of my former counsel when I was a commissioner, she sort of tongue-in-cheek said she didn't realize that it's now the Securities and Environmental Commission, because this rule, which is now stayed, the SEC has voluntarily stayed it, because a lot of good states have and others have sued in many different circuits around the country, and so but anyway, it would have it would expand the disclosure by companies and really make things revolve around climate disclosure and all sorts of subjective and very hypothetical effects and disclosures down to the zip code of what your factory might be in and things like that. It's pretty overreaching, I would say. And so that one stayed, and then that's with corporate disclosure. Then the SEC also turned to disclosure by investment advisors, investment managers, about what sort of if they have ESG funds, what's in them, what's the strategy, and focusing on the names as well, and then also about greenwashing, potential greenwashing, making things look greener than they really are, because the fees around ESG funds tend to be higher. So I think it'll be interesting when we talk about fiduciary duty, it's not just what the return, potential return of the investment might be, but it's also what it will cost the investor, and what the advisor then gets from that, if he has an interest in the fund or whatever. And then finally, the SEC is focused on proxy voting. So I don't want to get into that whole issue, but right here, unless y'all want to talk about it later. But every year, every company under Delaware and other state laws are required to have an annual general shareholder meeting to vote for directors and reappoint the auditors and things like that. And so that's how proxy voting, where the opportunity for shareholders to put forth precatory proposals to advise the directors and corporate management as to what the sense of the shareholders might be. Let's just say that politicized activists, quote unquote, investors who own the very bare minimum of what it takes to be able to, under SEC rules, put forth a shareholder proposal, have weaponized this whole corporate governance area and have used it to browbeat companies into going along with what these various activist groups might be propagating. And they're aided and abetted by two large proxy advisory firms that have grown up ever since the rule was adopted by the SEC over my no vote way back in 2003, early 2003, requiring investment managers and mutual funds to disclose how they vote their proxies, and no one ever said that they wouldn't tell you if you asked. But this then made it essentially into a compliance function and politicized things, as Jack Bogle and Ned Johnson warned of at the time. So anyway, so that has then skewed the operations and the management of public companies. And the SEC has basically opened wide the door, regardless of what the current rules say, as to what sort of shareholder proposals may be submitted and then put onto the proxy statement. A lot of interesting things going on there. Exxon sued one of these politicized shareholders. It's called Arjuna Capital. And that caused Arjuna Capital to say, never mind, we don't want this proposal to be on the proxy card. And Exxon said, well, no, there's no never mind about this. We want you, judge, to please look at this and give us a declaratory judgment. The judge demurred and said, no, thanks, I think it's moot. But it just shows that, these politicized shareholder activists overall don't have two nickels in their pockets to rub together to fund lawsuits. And if they actually are fiduciaries themselves, they can't use their beneficiaries' money to advance these sorts of things. So Exxon may well have charted a new path forward for companies to perhaps stand up to these things. Well, anyway, with that, that's sort of a quick overview of where the SEC stands right now. So it's still, I'd say, in abeyance is the bottom line, pending decisions in the court. And some of this may go up to the Supreme Court and really test, the whole major questions doctrine that the Supreme Court enunciated in West Virginia, in that West Virginia case last year.
Well, it is certainly a target-rich regulatory environment out there. And I will say kudos to Exxon. Arjuna finally, that lawsuit was finally dismissed as moot, but I think only when Arjuna promised not only that they had withdrawn the proposal, but that we will never do this again with respect to Exxon. Only at that point did the judge say that was a sufficiently binding commitment that the lawsuit became moot.
There are many other companies that they can go after, so that's kind of an empty promise, but whatever.
Yes. Well, I'm so glad that we have Ohio's Solicitor General here to speak to what motivated this lawsuit, Utah v. Sioux. Why did the states bring it, and what are your best arguments about why DOL overstepped its bounds here?
Well, thank you very much, and it's an honor to be speaking to all of you. about both of these topics. Ohio is involved in litigation both against the SEC and the climate disclosure rule that Paul mentioned, as well as a party to this Utah versus Sioux DOL matter. And in both instances, Ohio has proprietary interests as well as parens patriae interests. We're in the midst of what experts have termed the largest wealth transfer in history. Something like $68 trillion is going to change hands as generations retire and then pass on the benefits of their investments to their children and to other heirs. And when there's that much salmon in the river, there are bound to be bears who come a temptation to use those funds to advance an agenda, as well as financial, to try and capture as much of that wealth as possible. And the states in this instance, they have a benefit from capitalism doing what it should do. When retirees have their benefits maximized, when shareholder return is maximized for those who are invested in the stock market, states benefit from that too. For example, Ohio Revised Code 5747.01A makes some of that income taxable. And so if the Department of Labor rule is in force, we argue that we are injured because it reduces the investment returns that will be distributed to retirees and thereby reduces the impact that will have on the state's revenue. And moreover, in the SEC climate disclosure rule, it's the Ohio Bureau of Workers' Compensation that is actually the formal party to that action that has been now and when you have the climate disclosure rule at work, that can reduce those returns by incurring additional expenses to basically across the board all publicly traded companies that now have to do all the additional work involved in making those types of disclosures. But we also have a parens patriae interest in the well-being of our citizens and in the well-being of our businesses. Many of the states involved, the 26 states that are involved in the DOL lawsuit, not only have businesses engaged in the oil and gas and energy industries, environmental and social and governance factors come down on their funding costs and increase them. But also, we have in Ohio over 11 million citizens, and we want them to be able to prosper. And we believe that focusing on things that are not pecuniary factors reduces that ultimate prosperity. And so the states are going to continue to take a leading role in pushing back against what Paul wisely termed the whole of government approach. That whole of government approach is a good indicator that perhaps the statutes that Congress has adopted and assigned different lanes to environmental agencies and different financial regulators is not being fulfilled. And so the major questions doctrine is a great way to understand whether or not Congress has reserved these questions for itself or is likely to have delegated those questions to be answered by the unelected bureaucrats in Washington, D.C. And we think that when it comes to the Department of Labor, ERISA is abundantly clear. Fiduciary duty means that you are a of the sort of investments that are a true tie could result in a lot of people looking for ties so that they can then wet their beaks in that large stream of $68 trillion and say, well, maybe we can advance a social agenda or a political agenda with these funds. Or perhaps we can charge a higher number of basis points in returns because we're, of course, selecting more rigorously if we're doing environmental, social, and governance factors. And both of those things are the opposite of what Congress intended in ERISA. ERISA is there to ensure that the defined contribution plans and other retirement is as secure as law and applying the trust principles that were in the common law long beforehand. And so this is the legal principle where if you take a statutory term, it comes with the soil of the common law that comes with it. So fiduciary duties, duties of loyalty and duties of prudence. You can look to the treatises on this and you can look at the old case law on this and you'd say, well, Congress intended to transplant that soil with it and to limit and cabin the temptation to introduce factors besides that sole duty of ensuring that the fund is filled out and as available as possible to the retirees who are counting on it.
Well, thank you for that. So I'm going to, I listened to the argument this morning down in the Fifth Circuit, and the rubber really seems to meet the road with respect to this particular rule on this concept of the tiebreaker. As Sharon was saying, the term in the investment duties rule is where two investments equally serve the financial interests of the plan. At that point, it says that these collateral benefits, including those offered by ESG, can be used to break the tie. So I want to hear from each of the panelists. I'm going to go Sharon, Elliot, and then Paul. Is there really such a thing as a tie between two investment options with respect to the risk and return characteristics that it can offer to a plan? If not, does this rule really do anything at all? And if there is such a thing as a tie, what else would you use to break a tie at that point? So Sharon, what's your view on?
Yeah, my view on that, based on my financial background, says, probably not, in terms of where a tie would truly exist. And Paul may have more to say on this point as well. That was generally the skepticism that the Trump administration held, and that's even something that the attorney representing the DOL this morning admitted, that a tie would be rare. I mean, if you consider the type of risk return analysis that a fiduciary should engage in, investments are usually pretty unique across asset class and risk return and liquidity and investment time horizon. And if a fiduciary is prudently assessing all of those elements and properly diversifying a plan, or selecting a slate of investments for employees to choose from in their 401k or the like, you're going to have a really hard time finding something that's an actual tie. That's why, there's different factors that feed into changes in an investment that need to be reassessed over time. And fiduciaries are, regularly taking on that assessment, quarterly, annually, what have you, to make sure that the investments are properly serving the economic interests of the plan. The one area that we've already kind of touched on where perhaps more of a tie could occur, and this is one that the Trump administration, as I said before, considered based on feedback from plan sponsors. The Biden rule also references it in its preamble, might be in an investment that's outside your general, liquid financial markets type investment, something really in the private equity space or venture capital, or, a mortgage-based investment of some kind, where there's fixed return, there's a fixed time horizon, there's specific liquidity options. Perhaps there could be some equivalent options there where one plan might see some outside benefit besides the actual plan investment return, similar to what 94.1 said as far as the other economic considerations outside of the investment return to the plan. And the department has consistently said that, such decisions in a tie-breaking scenario would not be inconsistent with ERISA's prudence obligations. But that's going to be a very small part of a whole plan's portfolio. And even then, there may be other truly economic or pecuniary factors that should be considered in terms of the degree of investment in such of an asset, and also, just some of the double checks as to whether a fiduciary could actually do it or potentially violate some prohibited transaction requirements under ERISA. What the department seems to be doing here is to give fiduciaries some comfort in looking at ESG factors, but still on a financial basis. So that doesn't, in my view, really establish a tiebreaker scenario, but really kind of points more to asset allocation or diversification, which is what a fiduciary should be assessing on a regular basis anyway.
So that might suggest maybe we shouldn't be too worried about things. But Elliot, you guys brought the lawsuit. So obviously you guys thought this rule might actually have some real effect. People were going to at least think there were some ties out there where this might come into play. What's your perspective?
Well, we think that this rule really invites the temptation to find ties for improper purposes of considering collateral effects. When you tell this entire industry that you can maybe find a way to avoid the strictures of ERISA if you can find a tie, well, maybe suddenly, lo and behold, you start to find additional ties. And I think that the language isn't true tie. The true is, equally serves the financial interests, overall investment principles. It's sort of this vague, mushy standard. We think that's inconsistent with the language of ERISA, which provides a broad prophylactic rule to, as we say in our brief, we're quoting from the restatement third of trusts, that trust law imposes the duty of loyalty to stamp out even, quote, occasions of temptation. And we think that this is really inviting temptation in a way that is contrary to law. And, the other thing I would say is, to the extent that there are ties that are out there, it's really the burden on the Department of Labor to make the justification for this. Because either this is a thing that happens all the time that requires a rule, and they needed to consider that and explain that, or it's not actually something that happens in the real world. And so this is all just hypothetical. And why would they have created the rule in the first place? It's the burden of the agency under the Administrative Procedure Act to explain reasonably the reasonable choices that they're obligated to make under the APA. And we think that this rule is arbitrary and capricious, that it doesn't actually do that, because it's trying to have its cake and eat it too. It's trying to say these ties don't really exist, and yet to the extent that they do, and this is really important, then you can consider things like climate-related risk. One asterisk on climate-related risk, I think a lot of that it's interesting to hard code a certain type of risk above and beyond all the other types of risk. To the extent that climate change or other environmental factors present a material risk to investors, they're usually already obligated under the SEC rules to make those types of disclosures. And you would presumably think that prudent asset managers, consistent with their fiduciary duties, would review those investment choices and those disclosures by the potential investment vehicles that they might choose. And as Sharon described that, make that in terms of diversification and allocation of assets to ensure a right balance of risk and return. And so if that really is the state of the law without the new ERISA rule, then it begs the question, why do we have this new rule? And that's a question that the Department of Labor has to answer. That's their burden. And so we think that this lawsuit is very important to really put them on the onus of explaining themselves. So not only is it contrary to law, but we think it's also arbitrary and capricious because they can't explain themselves because they're trying to dance between this have their cake and eat it too sort of scenario.
The Supreme Court famously bought into Massachusetts' concerns that climate change was going to mean it lost its shoreline to the Atlantic Ocean. Is Ohio not concerned about losing its shoreline to Lake Erie?
Well, we always want to be a good custodian of our natural resources, which include the Great Lakes. Ohio has a north coast, and we are the north coast of the United States in that part of the country. So,
excellent. Paul, what's your perspective on this from the SEC? Is there such a thing as a tie between investment options? Is this much ado about nothing, or is this real?
Yeah, well, so I'm not an expert on what goes on at the DOL and whatnot, but I would be, just like you all have been saying, very skeptical that there is ever a case of a tie, because there are always other factors, like Elliot and Sharon were saying, that come into play, and especially when you look at the attributes, the requirements of fiduciary duty, where under the SEC construct, you have two basic types of people who help investors: investment advisors, who are governed by one statute called the Investment Advisors Act of 1940, and broker-dealers governed by the Securities Exchange Act of 1934. The two standards have pretty much come together, even in the Trump years overall. But the investment advisors' true fiduciary duty standard, which was imposed on them by a Supreme Court case in the 1960s, called SEC versus Capital Gains. But basically, the Supreme Court set out the test that an advisor has to act in all times in the best interests of its client and not subordinate its client's interests to its own. So duty of care and a duty of loyalty, and those now being put onto brokers also who are agents of investors versus true fiduciary advisor. And so there's a lot of history around all of that. But as I mentioned, in the Trump years, a new rule called regulation best interest, or BI, was adopted that pretty much aligns the broker's duties with those of advisors. So when it all is said and done, coming down to analyze things, so whether it be something very speculative, like, there was a few years ago, again, going back to the weaponization of corporate governance, there was a big kind of thrust of politicized activists putting in shareholder proposals at companies to ask for a report for the company to say, what would the effect in 80 or 90 years hence, in the year 2100, if the average temperature of the Earth has increased by 2% or 2 degrees centigrade. And so they were supposed to analyze, like, what do you think the company will be able to survive it? How's this going to work with our products? And then take into all sorts of other account the speculative nature of what might happen in those ensuing years. And if you looked backwards in when the first list of the Dow index companies came out, there's no one left. They've all either merged out of existence, gone bankrupt, or been acquired, but there's none of those original Dow companies are in the current Dow 30. And so, how are we supposed to look at these sort of speculative investments? So going back to, or speculative things that may happen. So going back to analyzing an investment now, whether it be, is it safe to invest in a coal mine in West Virginia, because of what may happen on the regulatory, horizon? Who knows? You'd have to obviously analyze that and look at what the potential returns might be versus, a wind farm out in Utah or Ohio or wherever it may be, and and then try to gauge those, and then whatever the costs of investing and everything else. So, those sorts of trying to compare apples with oranges, I think that is probably very rarely you'd ever find something that is a true toss-up. And even if it were apples to apples, then I think it would be very highly unlikely that it would come down to a basis point or two, which would be essentially a toss-up, but still there's a basis point difference which can add up over 30 years. So anyway, so I think that's basically a lot of sound and fury, probably about nothing.
So I think I'm hearing, particularly from Sharon and Paul, true ties very rare. But I think I hear from Elliot, but maybe manufactured ties not so rare, in the sense that if you really did all the homework, you could probably find what was the truly better investment for the plan. But it's also hard sometimes in the universe of choosing between a dizzying array of investment options to say, by a preponderance of the evidence, it's absolutely clear that this one was better than another. And maybe in that environment, I take it Ohio's concern is it's all too easy to let the temptation to dip the beak into that $68 trillion stream to say, they're close enough. So let me pick the one that's got ESG factors. And no one's ever going to be able to prove beyond the shadow of a doubt that the other one was really better economically. Am I capturing the concern of Ohio there, Elliot?
Yeah, we say in our brief that the way that Congress constructed ERISA was to stamp out temptation and to really focus the mind of fiduciaries on an exclusive list of things that they're supposed to think about. We don't have something like the bankruptcy code where you have, first consider this, and then if that, then you go to the next thing, and then you go to the next thing, and you go to the next thing. It's really, you have this set of duties, and they're well defined, they're well understood in the case law, and you need to focus on those things. And there's a good insight in that temptation to consider things that are not ultimately in the best interests of the retirees might be all too real. And so you need a legal duty to ensure that this kind of retirement income is secure. And, ERISA was passed by Congress with acute concern for how pensions had sometimes failed to deliver on their promises. And so they were trying to create a system that compensated for those risks. And one of the ways that Congress did make a decision, rather than delegating decision-making authority to an administrative agency, is you need to focus on these things, and they are going to be pecuniary things. And so you're very right that from a game theory, economics, law, and public choice perspective, that information costs are genuine, and when you have a lot of different investment vehicles that you can continue digging and digging and digging, eventually there are diminishing marginal returns from that. A way to think about ERISA is we're saying you need to go to that point where marginal cost and marginal utility actually intersect on the pecuniary factors. And if you do that, then I think Paul and Sharon are quite right that you're almost never going to find something that has the exact same number of basis points in terms of cost allocation. You're never going to find something that has no additional financial pecuniary benefit over another thing. And but if you allow sort of a way out, you might not actually do that kind of diligence that you need of acquiring information about the investment vehicles that you're going to invest the hard-earned funds of millions of American citizens, including millions of Ohioans.
One thing just to throw in as a corollary to that, and I think this is if I were a state AG or a plaintiff's lawyer to put a hat like that on, is that it's not just pecuniary in the dollars and cents version, but it's also the duty of loyalty means something absolutely, and especially under ERISA law. Some states are squishy. I don't know. I can't remember how Ohio is, but or squishier than ERISA, but it's if there is anything that diverts your unerring loyalty to your client, as far as just separating your own personal potential gain. So, for example, maybe I'm going off to a conference and speaking on an ESG topic, and how great our ESG funds are, or how great our trying to earn my keep there, or chum it up with people. That that's a personal benefit than if I'm then trying to put clients into some special type of investment. And there may be a trail of emails, which obviously those are sometimes the lawyer's best friend when he's trying to engage in a suit and whatnot. So that could then be like a trail to a bad outcome for that advisor. So, I mean, in a way, maybe this whole, rule is a way to try to help settle down the angst by some advisors, like, how are we going to be second guessed in the future? And, but I'm not sure that is going to be able to, help people in the event of some of these types of challenges.
And Sharon, what's your reaction? So you heard Elliot's expressed concern that maybe we need something more of a prophylactic rule, a safeguard against the temptation, because maybe true ties are rare, but that's just the point. Why in the world do we have this rule about ties if it never really comes up? So what's your response to that? And is the rule appropriate in light of that concern?
Well, it's interesting because the court was pretty focused on that this morning as well. They asked the attorney representing the DOL kind of the same question. Why is there all of this hoopla with Amici supporting, consideration of ESG factors if having a tie is just extremely rare? That's where the DOL, regardless of which administration, needs to continue focusing on the language of the statute and of ERISA, and focusing its guidance on those requirements to do the risk return analysis based on monetary benefits to the participants and beneficiaries. That's what ERISA requires. To the extent, and I think a lot of that, or some of that, can come through DOL enforcement. Some of that will certainly come through civil suits challenging these things. Perhaps now, post Chevron, the courts will be a little more willing to take a look at changes to regulations, or the way that an agency is enforcing the regulations that it's put out. or whether a new regulation is consistent with the statute that it's been promulgated from. So, yeah, I tend to agree with Elliot a little bit there that there does need to be some stricter parameters in guidance to explain what the statute is, which is what the Trump rule attempted to do. Put those guardrails again around consideration of these factors.
And you mentioned the post Chevron world there, Sharon, and I want to give each of the panelists a minute and a half as we close things out here to just, we've seen what could be seen here as sort of regulatory whipsaw. 1994 rule followed by interpretation, followed by a 2008 interpretation, a 2015 interpretation, a Trump rule, and then a Biden rule. A lot of regulatory whipsaw in there, not a lot of stability. With Loper Bright and the overturning of Chevron, do you have hope that this kind of whipsaw, there'll be less of it going forward? Is this going to allow the courts to speak more forcefully to what the duties should be and make the regulators take more of a back seat to that? Or how do you think that will be, Sharon?
Sorry, you broke up a little bit there. Did you say me first? I think so. Okay. So on this, that's a question also that came up in the arguments this morning. Because the court did do some review of Chevron in its decision, it's likely that it will get punted back down. Whether the analysis, though, is going to change is something that the DOL attorney was questioning, because if the rule is consistent with language in the statute that requires review of the pecuniary factors, then in financial interests of the participants and beneficiaries, then maybe there's not much to see here. But to your question, I am hopeful that this does mean that going forward, the courts will take a bit of a stricter view of an agency's interpretation of the statute, given what the statutory language is, given what the purpose of the statute is. Here in ERISA, it's very clear that the duties a fiduciary has are solely to the interests of the participants and beneficiaries and for the exclusive purpose of providing retirement benefits to them. And anything straying from that, I think, should be questioned by the courts.
Elliot, what do you think?
I think Sharon is exactly right. Chevron operated under this hopeful premise that the political accountability that flows to the president by virtue of him being elected by all the people would flow down into the administrative state, into the agencies to which and I don't think it really happened. I think what you ended up having is courts finding ambiguities in statutes when they really should have been reading those statutes to be clear. And I think that it will reduce regulatory whipsaw at the margins to eliminate Chevron. And in this case, I mean, the statutory language seems to have a very plain meaning. 29 USC 1103 and 1104 make clear that the duty of loyalty requires fiduciaries to act, quote, solely, unquote, and, quote, for the exclusive purpose of providing, quote, benefits to participants and their beneficiaries. Solely for the exclusive purpose of providing benefits to participants and their beneficiaries. That's pretty clear. There doesn't seem to be a lot of ambiguity there for the Department of Labor to say, well, and solely doesn't really mean solely, and exclusive can mean non-exclusive and inclusive of other collateral factors. So I think that it will make a difference, especially in this case where the district court made its decision on the basis of the now overturned and moribund Chevron doctrine.
And Paul, a final closing thought from you on Chevron.
Yeah,
well, for the administrative state.
Okay, yeah, well, let's see. Unfortunately, things have become much more politicized than when I first had my first job under Richard Breed in 1990 at the SEC as chief of staff. But I think that Chevron, it was bound to obviously be done away with by the court. If you look at the history, it was as a reaction to all the activist judges in the 70s and the early 80s. And so there's a way to try to get things back to center. And then obviously in the wake of West Virginia versus EPA and all of that, there's just the how the government agencies have taken statutes and tried to just explode them into all sorts of other areas where they were never even contemplated by the drafters of it. So I think that it will help get things back, but in maybe 40 years, you'll have to go back again, as we've been talking about the ping-ponging back and forth between administrations. I think that's too bad. In the regulatory agencies, they need to go back to square one and focus on what the intent of Congress was.
Well, and I just want to thank everybody who tuned in to this this panel. I want to thank all of the panelists for just an excellent and erudite discussion, both of this incredibly important topic that impacts trillions of dollars of retirement investments that are supposed to be shepherded and safeguarded for the interests of participants in those plans to make sure that they'll have their retirement investments there, and for the commentary on the administrative state more broadly. I think there's a lot to learn through the lens of this particular episode. Steve, I'll turn it over to you to close it out.
Thanks, Greg. And I want to thank this entire panel, a stellar panel of experts on this really important topic, as Greg noted. And I want to thank the audience for tuning in. For more information and more programming like this on the regulatory state and how it impacts the American way of life, please check out regproject.org. That's regproject.org. Thank you.